In the second part of the page, it starts with the expression "a court of law" has not been defined in Article 62.
Which placidum are you referring to?
Double S, my lord.
Double S. G.
From the middle.
G. Read it.
The expression "a court of law" has not been defined in Article 62 or any other provision of the Constitution, but it essentially means a court of plenary jurisdiction which has the power to record evidence and give a declaration on the basis of the evidence so recorded. Such a court would include a court exercising original, appellate or revisional jurisdiction in civil and criminal cases. But in any case, a court or a forum lacking plenary jurisdiction cannot decide question of this nature, at least when disputed.
What is plenary jurisdiction?
Plenary literal meaning is a court exercising full powers. All the powers.
Plenary jurisdiction means where the original jurisdiction has been exercised under Section 42. If you mean to say that Section 42 of the Specific Relief Act can be exercised by the High Court under Article 199 and 184 and 185 by the Supreme Court.
No, my lord.
So declaration means for all such type of declarations, the case must be under Section 42 or not?
It need not to be under Section 42.
Then,
that is my submission.
Then how the declaration can be granted in any other law?
Declaration can only be granted by election tribunal. That is my submission.
It means that it exercises the jurisdiction under Section 42.
Not under 42. Under Representation of People's Act or Election Act. That is the only forum.
And after recording evidence or without recording evidence?
After framing issues, now I will come to the power of the election tribunal.
This can be exercised by the High Court directly?
It cannot be exercised by the High
Supreme Court directly?
No, my lord. Supreme Court in appellate jurisdiction.
Your last argument is in contradiction with the judgment you have relied. 490 पे आइए दोबारा.
My lord.
जहाँ से पढ़ा था उससे दो लाइनें ऊपर. Even the election tribunal.
Even the election tribunal, unless it itself proceeds to give the requisite declaration on the basis of the material before it, would not disqualify the return complaint where no declaration, as mentioned above, have been given by a court of law. Now I will demonstrate how I say election tribunal is court of plenary jurisdiction.
नहीं provisions बताए ना कि वो नहीं है, वो भी नहीं कर सकता unless by the court of law.
Let me explain the formation and the power of election tribunal.
आपका आर्ग्यूमेंट ये हुआ ना कि सिर्फ प्लेनरी जुरिसडिक्शन के कोर्ट्स डिक्लेरेशन दे सकते हैं और आप कहते हैं कि अदर देन द नॉर्मल रेगुलर प्लेनरी कोर्ट्स लाइक सिविल कोर्ट्स एंड ऑल द इलेक्शन ट्राइब्यूनल आल्सो फॉल्स इन दैट कैटेगरी. This is your argument.
This is my argument. I also say that
कौन से सेक्शन में ये पावर
in constitutional jurisdiction.
Show us the please provisions of the law. Election Act में कौन से provisions है declaratory jurisdiction exercise करने की?
My lord, उसमें मैं आ रहा हूँ. Basically, election tribunal is constituted.
No. Election tribunal is a different thing. आपने कहा ना election commission भी ये power exercise.
I'm saying election tribunal.
Election tribunal की जो power है वो तो फिर civil court के power हैं उसके पास सारे.
Yes, my lord.
And they can exercise the civil court powers and they can record evidence because
my lord,
before declaring any person disqualified, they must be.
Not true. The provisions
but this debate won't resolve what the problem before us is. Let us not go into the powers of the election tribunal. Here, the power is, it's not a question of election tribunal exercising a power or election commission exercising a power. It's the power being exercised by a constitutional court. Now, you premised your argument by saying court of law is not defined anywhere in the Constitution. Can I first of all correct your premise and take you to Article 175 of the Constitution? If you read that Constitution provision, the chapter is titled The Courts. And now please read 175.1 and then 175.2. So I may be subject to correction, but there are courts of law and the courts, Supreme Court and the High Courts have other powers as well. Please read.
My lord. There shall be a Supreme Court of Pakistan, a High Court for each province, and a High Court for the Islamabad Capital Territory, and such other courts as may be established by law.
By law comes here. Now read subsection 2.
No court shall have any jurisdiction save as is or may be conferred on it by the Constitution or under any law.
Now, first of all, then the court has been defined. There are Supreme Court, there's the High Court, and any number of courts that a law may enact. Correct?
My lord.
So it is a clear distinction between the Supreme Court, the High Court, because the Supreme Court and the High Court exercise, and I presume this is the distinction, there is appellate power of the Supreme Court and the High Court where it acts like a court of law.
My lord.
And then there is an extraordinary constitutional jurisdiction of these courts,
my lord,
which it does not in the classical sense act as a court of law, but as a constitutional court. Therefore, they are called constitutional petitions. And we used to earlier write extraordinary constitutional jurisdiction. So it's an extra jurisdiction conferred by the onto the superior courts of Pakistan. And now we come to sub-article 2. No court shall have jurisdiction save is or may be conferred on it by the Constitution or by or under any law. Now, Article 199 confers jurisdiction under the Constitution, which is in addition to appellate jurisdiction. Article 184(3), other articles of the Constitutions confer certain jurisdiction onto the Supreme Court. Does Article 62(1)(f) confer any jurisdiction on the Supreme Court? That is the question. Because there it says court of law, not the Supreme Court, not the High Court.
My lord.
So surely we cannot interchangeably use these terms. If it had not used the words court of law, which it does, so then it is, otherwise this power should have been mentioned in Article 184(3), or such powers as can be exercised by High Court under Article 199 or whatever it used to say. So we cannot just disregard the two concepts of a constitutional court and a civil court under Section 9.
My lord.
You assumed a lot of things.
Because when I use the word, it has not been defined. The phrase court of law is not defined.
It is. Because I've just read 197.
Supreme Court and High Court, that's the word they use. I am just referring to the phrase.
Are you saying Supreme Court is one and the same court, but then it's exercising appellate jurisdiction as opposed to extraordinary constitutional jurisdiction?
No, my lord.
So technically speaking, they're two separate creatures.
My submission is anything arising out of election tribunal is decided by the Supreme Court in its appellate jurisdiction.
Correct.
Any declaration in election tribunal or by the Supreme Court in appellate jurisdiction is covered under 162(1)(f). Not any power under 199.
No, थोड़ा सा और clarify कर देना. Election tribunal will exercise powers only under the law, which used to be the Representation of People's Act and now is the Election Act of 2017, correct?
My lord.
Therefore, when the Supreme Court is exercising such powers, it cannot have more powers than the Election Tribunal or the Election Commission of Pakistan. Unless you can show that the Election Commission of Pakistan and an Election Tribunal can also disqualify for life, then that power, of course, will be with the Supreme Court as well. Otherwise, it will be an additional power given to the Supreme Court under 62(1)(f).
Mr. Khurram, could I just summarize what you're trying to say?